Good morning, Mr. Shaw.
Good morning, Your Honor. Madam Chief Justice, and may it please the Court. My name is Robert Shaw. It's my privilege to appear before you today and to represent Paul Shanley. The accusations in this case arose from images appearing in the mind of the accuser 20 years after the alleged conduct at issue. They are images that were contradicted by the evidence at trial. They are images that had no integration in the accuser's own understanding of his personal history and memories of his past. And so the government used the notion of repressed memory as a critical explanatory link to normalize assertions which were otherwise extraordinary and to bridge what was an immense gap between allegations on the one hand and credible allegations on the other. And what I assert to the Court today is that the true scientific status of the repressed memory hypothesis is itself evidence that Paul Shanley did not receive the effective assistance of counsel and that the judge erred in denying our motion for a new trial. Repressed memory is a theorized phenomenon. It is not generally accepted by the scientific community. It has not been shown to exist, and it is not admissible. That has been demonstrated not only by the substantial record that we have produced for this Court, but by more than 100 experts who have gathered together, not just from throughout the United States, but from 8 countries across the globe, to communicate directly with the Court through an amicus submission, to cut through the inaccuracies regarding repressed memory.
Help me to understand what you mean precisely by repressed memory. Is it your position that no one ever forgets something over a long period of time and then for some reason remembers it?
No, that's not our position. Certainly, individuals can forget things and then recall them. And the experts who look at this from a scientific perspective are very clear on that. Repressed memory is a situation where somebody supposedly represses a memory such that it is inaccessible to normal memory function.
Okay, but Dr. Choi didn't testify, as I recall, to repressed memory. He specifically said, I'm going to use the term dissociative memory because, in part, because of the controversy over the process of repressed memory.
And Dr. Chu confused the issue, which is something that often happens. But if you look at his testimony, the record is absolutely clear that Dr. Chu indicated that what he is talking about is a memory that is inaccessible to memory. Someone is unable to remember. Now, that is exactly what the allegations were in this case. We have an individual who says that he was repeatedly abused week after week after week for a period of years. After every abuse, he forgot it again, walked into the abuse again, and then for 20 years thereafter, he was completely oblivious that he had ever been sexually assaulted. He had no memory of it whatsoever. And then, 20 years later, he had images in his mind, and even then, he conceded in the solitude of his own journal that even he was unsure whether these were thoughts he was just thinking or memories of actual events. That is not the function of ordinary memory. As Dr. Loftus testified, ordinary memory is we have a memory trigger.
I mean, as a sort of, as a procedural matter and as a structural matter, you've got a trial, you've got evidence, you have a judge holding an evidentiary hearing on this subject. Why should we take your view now as God's truth?
Your Honor, because the evidence is overwhelming and because you have a citizen who was prosecuted, convicted, and imprisoned based upon inadmissible evidence. It is a theory that is not accepted. We have rules, we have laws for when a theory like this can get to a jury, to influence a jury, to act as a critical explanatory link for the government to try to prove their case. That is why.
But what is your theory? That if somebody forgets something for a long time, they should not be permitted to testify to it?
You cannot have experts who come into a legal proceeding and tell a jury wrongly that this is fairly common, 20% of the clinical population experiences this, this is generally accepted, it's well known.
Is dissociative amnesia classified as a mental disorder in DSM-IV?
Well, Your Honor, again, we have to be careful about labels, but the very important part about the DSM is that, as the experts have testified in great detail, the DSM is a dictionary. It is a classification system that facilitates the uniform use
So
of
attacking
language.
the DSM, that's what I got from your brief.
Well, Your Honor, the DSM is a dictionary of diagnoses. It's not a scientific document.
But
It doesn't,
haven't we relied for years on things that the DSM says?
Your Honor, if you are dealing with some sort of phenomenon that is basically generally accepted, then I don't think it's necessarily error for the court to cite the DSM as further evidence that this is something that's established. But when you have a phenomenon that is not generally accepted, that's absolutely clear. One cannot rely on a dictionary, essentially, to say this is generally accepted. The
Do
DSM,
doctors rely on the contents of the DSM?
the doctors rely on the contents for the DSM when trying to use uniform language and labels and
It's
diagnoses.
got more of a use than that.
Your Honor, the DSM does not cite scientific evidence. It is not a scientific document. It is put together by individuals who are interested in a subject area, clinicians. If you look to Dr. Chu's testimony, that's the Commonwealth's expert,
I know.
even he asserts in his testimony, and it's cited in my brief, that the DSM is put together by interested individuals. Dr. Pope has 8 specific points of why the DSM cannot be relied
Isn't
upon.
everything put together by interested individuals? I mean, otherwise, why would we have anything? Nobody.
No, Your Honor, it is not. When there is a supposed phenomenon, such as repressed memory, it must be a scientific community, someone who has valid methodology and tests something to determine whether it should be generally accepted. And it's absolutely clear that, when you look at the amicus submissions in this case, it's extraordinary. You have the most prominent scientists, psychologists and psychiatrists who are asserting that this is not generally accepted. So why would we allow it into a court of law in a criminal proceeding?
But I'm trying to understand what you're asking a judge to do. Well, let's assume that you have a case, as we have here, in which you have an individual who's the alleged victim was prepared to testify to a memory that had been forgotten for a very long time. Is it your position that the judge should allow that individual to testify but not permit expert testimony as to the...
That's exactly right.
So it's okay that this alleged victim testified, but you don't want the jury to hear anything as to how common it is, as to whether there's any clinical evidence as to this being a diagnosis or something that occurs in a clinical population. Is that what you...
Your Honor, nobody can prevent an alleged victim from going into a courtroom and testifying that, yes, I remembered this.
And so I take it that you couldn't have any experts either, correct?
Well, that's correct. We wouldn't, look, an alleged victim can testify that I remembered this. That's why we have the fresh complaint doctrine, right? I mean, the fresh complaint doctrine used to assist in determining, well, there's been a delay. Yes, it's true. Alleged victims who have been abused, especially if they've been young, some of them delay in reporting. Some of them don't understand the harm that has happened to them. But to have an expert come in, clothed in authority, to say that this was a memory that was inaccessible to consciousness, that's how this individual went for 20 years oblivious to the fact that he had ever been abused.
Well, if you don't permit that kind of testimony, then a defense lawyer is going to, I take it, is going to argue to the jury that this witness is an absolute crackpot. And that there's no explanation for it, when in fact that there is an explanation for it. There are a large body of scientists. Whether or not they're in the majority or not is a question. But there are still a large body of reputable scientists, psychologists and psychiatrists who believe there is an explanation for this. And the American, the American Board of Psychiatry and Psychologists have voted to use this particular terminology, repressed memory or amnesia dissociative disorder, in their diagnostic manual for use by other psychiatrists and psychologists.
Your Honor, the DSM is not scientific evidence. If you want to talk about memory distortion that might occur, we have no argument with that. We're talking about massive serial repression where somebody lives their life not understanding that they were abused.
But my question is, won't a defense lawyer then call this witness a crackpot and there's no explanation, that witness or the Commonwealth would be left with absolutely no explanation as to why this witness testified in the manner in which he or she testified.
And
But that's what a defense lawyer will do.
but, Your Honor,
Is there a yes answer to that question or a no answer?
the answer is yes, and
Okay.
the reason is that citizens who are accused of crimes have the right to defend themselves. People who
Okay.
are accused of crimes have the right to challenge credibility.
And then doesn't the party who's offering this evidence have the right to offer an explanation in response to that challenge to the lunacy of the witness's testimony?
Your Honor, if there is established in the scientific community, now you've indicated that you believe that there is, but in fact there is not. Now, there are psychiatrists and psychologists who use dream therapy. They have birthing therapy where they wrap them in a blanket and they reenact their birth. Certainly we wouldn't be relying on them.
Is there a significant number of psychologists and psychiatrists who do find the use of the term repressed memory useful in explaining this phenomenon?
Your Honor, again, we're talking about massive repression. We're not just talking about memory distortion. I just want to make that absolutely clear.
Yeah, I'm just looking for an answer to my question.
But the answer to your question is that there are clinicians who suggest that given their experience in clinical therapy that they think this exists. But we have to go beyond clinical judgment. Clinical methodologies are not those that we use to determine whether something is generally accepted in the relevant scientific
Well,
community.
general acceptance is one of the criteria, isn't it?
It is the main criteria.
Okay, but
it is the main
but it is
criteria.
not the determinative criteria.
I believe this court has said that it will remain the primary criteria.
If it's generally accepted, it's admissible, but there are other ways it can be admissible as well.
Mr. Shaw, may I ask you this question? It seems to me that your claim here that defense counsel was ineffective, in your words, to pursue the issues surrounding repressed memory. So I understand that regardless of what the status of DSM is, you are taking the position that there is a version that says that it's beyond ordinary memory loss. If defense counsel had vigorously pursued the issue of repressed memory as you are advocating it now, it's not accepted in the scientific community. We don't look to what some clinicians may use in dealing with their patients or their clients. And if there had been a full presentation of that to the trial judge in a Lanigan hearing, and the trial judge had concluded, even it said it's not generally accepted, but I'm going to allow it to go to the jury, would we be in the same position here?
Well, we wouldn't have ineffective assistance of counsel, but we would be in the same position in that the judge had ruled wrongly in a Lanigan hearing, which is not,
But here your claim seems to be slightly different, which is that the judge may have been incorrect in his ruling because there wasn't a vigorous assault on this particular form of alleged memory loss.
Well, there are two things. First off, trial counsel was ineffective in the fact that he raised the issue. He repeatedly represented the court that he was going to present evidence. He then didn't present a single expert. He didn't present a single study to the court. Okay? And that was clearly ineffective. When he got to trial, he did not mount an adequate case against the notion of repressed memory. He called somebody who was a scientist, Dr. Loftus, concerning suggestion, and he tried to get at the science, but he didn't do that adequately. So there was ineffective assistance of counsel. There was ineffective assistance of counsel at trial. We filed a motion for a new trial. We demonstrated to the judge, and I think it's very important to look at what the judge did here. The judge did not confront the demonstrated reasons we presented for why his reliance on Dr. Brown's testimony was erroneous, that the relevant community had been misdefined. Dr. Brown had relied on deficient methodology without standardization or any error rates.
What do you mean the judge didn't confront it?
He didn't address it in his decision. He simply reiterated his earlier conclusions, and he says, well, there doesn't need to be unanimity for there to be general acceptance. He didn't recognize that the enormity of the controversy surrounding repressed memory itself decisively contradicts the notion of general acceptance.
When you say the defense didn't present any evidence at the hearing, didn't Dr. Loftus, wasn't an affidavit of Dr. Loftus's presented?
Well, it was entitled a preliminary affidavit when filing the motion, but nothing was done during the hearing other than cross-examination questions, all of which were disputed and therefore didn't come into evidence. And so, no, he didn't call a single expert. He didn't submit a single study. And I want to just also be very clear, because it's a very important issue. Even if we accept the fact that repressed memory was admitted in this trial, there was serious grave error because the prosecutor argued outside of the evidence. She argued to the jury that they could look at this as something that was no different than ordinary memory, that this was no different than going to a reunion and remembering something by seeing somebody you hadn't seen in a long time.
But the Commonwealth argues that that was based on the testimony of one of the experts.
And it was not, Your Honor, and that is very clear in the record. And I've set it forth in my brief at page 47. If you look at the footnote, it was a misrepresentation of Dr. Loftus's testimony. Repressed memory, by definition, is inconsistent with the functioning of ordinary memory. And this was incredibly prejudicial for at least 3 reasons. The defense had litigated this case solely as a repressed memory case from the grand jury forward. This case was tried during trial as a repressed memory case. The defense counsel even argued to the jury in his closing argument that if you can't believe in repressed memory, you can't believe in the government's, in the allegations of the accuser. And the fact is that that was extraordinarily prejudicial, because then at the end, all of a sudden the Commonwealth switches. They argue, hey, you can credit these images in the mind of the accuser because it's no different than what happens to any of us every single day.
Mr. Shaw, if there are no further questions, thank you.
Thank you.
Ms. Lilios?
Good morning, Your Honors. My name is Loretta Lilios. I'm an Assistant District Attorney with Middlesex, and with me is Assistant District Attorney Bethany Stevens, who is prepared to answer any questions that the court may have on the jury instruction regarding the statute of limitations.
Can I ask you this? Let's assume we conclude that the scientific view of repressed memory has so shifted in the interim years that it would be inconceivable that it would be admitted in a trial today. What should we do about that in this case?
Well, the Daubert and Lanigan cases address a situation such as that. And that's why, although general acceptance is the default standard in Massachusetts, if since the most recent DSM-4 TR was published, there has been a dramatic shift, and the defense puts forth a preliminary showing of that, then a preliminary Lanigan-type hearing would be appropriate.
You mean in the next case? I'm talking about this case. Let's assume we conclude, and I'm not speaking for anyone, just saying assume we conclude that the scientific view has shifted dramatically on repressed memory over the last 5 years, 10 years, and that it would not be, we would not sign off, or we would not conclude that it would be admissible today. What should we do about this case?
Well, I think cases that were tried previously would need to be held to the state of the science at the time. A Rule 30 motion based on newly discovered evidence might be an appropriate vehicle for a defendant to gain relief. But that is not the situation here. And the situation here is that the defendant agrees that the victim was properly permitted to testify, that he forgot about the abuse for many years and then remembered it following 2 telephone calls from his then-girlfriend. And yet he says that the Commonwealth was not entitled to offer the testimony of Dr. Chu at trial that would have shed light on the victim's credibility and would have assisted the jurors in evaluating the victim's credibility, which without the expert testimony, the jurors naturally would have tended to attribute the victim's testimony to inaccuracy or prevarication. And
I understand that, Ms. Lilios, but I go back to, really, from my point of view, the ineffective assistance of counsel claim. It seems to me that neither the Commonwealth nor the defendant, but certainly not the Commonwealth, is disputing that, I think this goes to Justice Gantz's first question, that there is something recognized, whether you call it dissociative memory loss or ordinary memory loss. I mean, all of us have had an experience where something happens and it triggers a memory. Whether or not the memory is an accurate memory of what happened at the time, we've all of us, I think, had experiences where the classic is you go back to your childhood home and it's much smaller than you remember it. Memory doesn't always mean facts.
Well,
Here, both the Commonwealth and the defendants seem to recognize that there is something called repressed memory, which is at the extreme end. The defendant claims that it is inconsistent with how memory functions. The Commonwealth says, no, it's not inconsistent. Lots of people recognize it. It appears that at the Lanigan hearing, to say nothing of a trial, counsel, either because counsel was not really up to speed with the relevant scientific material or for whatever reason, didn't aggressively present the potential conflict, the great divide in the scientific community, which existed even at that time.
Well,
Doesn't that raise some concerns?
Well, I take issue with counsel's performance at the hearing. Looking at counsel's performance at the hearing, it is clear he made representations that he had retained an expert and that he was faced with the difficult decision about whether to call that expert for purposes of the hearing. He ultimately made the decision, what I suggest is a reasonable tactical and strategic decision not to call the expert for the hearing. But he also crossed the Commonwealth's expert, Dr. Brown, on specific studies. He crossed him on the Anderson-Green word pair study. He was clearly very well versed in that. He crossed him on the Sargent and Slater Dunkirk study. He crossed him on the Loftus and Burns football study. Football jersey study. He crossed him on the Gunjansen suggestibility scale. And he also crossed him on the final report of the American Psychological Association, which indicates that and concedes that some people, although most people remember chronic abuse, some people forget them, but indicates that there are problems with pseudo-memory formation, which was squarely before the judge in the Lanigan hearing. And Dr. Pope's views about the definitive prospective study were squarely before the judge
Do we
at
have
the
any
Lanigan hearing.
affidavit from the defense attorney?
There is no affidavit from the defense attorney, and according to the Goudreau case from this court, you can make an inference that their defense attorney had nothing helpful to say for the defendant. But that begs the question about whether the Lanigan hearing was even required in the first place. And the judge was guided by the Frangipane case, which this court decided in 2001. Which
I have to say right up front, I do not agree with you that we decided the issue. I mean, reading it in hindsight, there's some confusion in the last paragraph versus, the sentence that just precedes it that says we're not deciding it. But I don't think that we decided that you don't have to have a Lanigan hearing. That's my own read of it.
Well, in that case, Your Honor, I would suggest that the presence of the diagnosis in the most recent edition of the DSM-IV is compelling evidence that this phenomenon in this diagnosis is generally accepted in the relevant community, which was
Well,
used...
what do you say to your brother's argument that the DSM is just a dictionary?
Well, Massachusetts appellate cases and appellate cases throughout the nation have referred to the DSM as a recognized standard authority. It is published by the American Psychiatric Association. It is a consensus document, and although the studies relied on are not cited in the document, the preface to the document does confirm that the sections are based on systematic reviews of published materials and that it is an evidence-based process that also looks at, that reanalyzes data sets with each edition. And the section dealing with dissociative amnesia specifically notes that there is a controversy in the field about this and highlights exactly the concerns about the suggestibility of memory, the potential fallibility of memory, and all of the thrust of the defense arguments that were before the judge at the hearing, that were before the jury at the trial, and that are before this court. And if you carefully read the affidavits of the defense experts that were submitted in conjunction with the motion for new trial, and if you look at Dr. Loftus's testimony, none of the experts say that this phenomenon does not exist. They say that they are not convinced that the scientific evidence proves it, but all of that was before the jury. And I suggest that this evidence is not that different than evidence that this court has deemed to be properly admitted without a Lanigan hearing in the Dockham and Hudson line of cases, where the symptoms of child abuse, including delayed reporting, recantation, and, I'm quoting the court, repressing the abuse, are proper information to put before a jury, because without that information, the routine indicia of reliability of a witness, which is consistency in the story, prompt reporting, all of this would not be put before the jury, and the jury would be deprived of the ability to satisfy their truth and fact-finding mission.
If I can go back to the DSM, during Dr. Chu's testimony, page 8129 of the transcript, defense counsel reads a portion of the DSM to Dr. Chu, who appears to accept it. And let me read you the sentence which caught my eye. There is currently no method for establishing with certainty the accuracy of such retrieved memories in the absence of corroborative evidence. Is there a due process issue when a prosecution relies upon repressed memory without corroborative evidence, and do you have enough corroborative evidence here to cross over that line if we were to accept that proposition?
Well, the defense is dismissive of the quality and the quantity of the corroborative evidence in this case, but I think that position ignores that the type of predatory conduct at issue here naturally is not going to occur in the presence of an eyewitness or a photograph or a
Nobody's
videotape.
asking for eyewitness testimony.
Then
So
if
what-
I can summarize the corroborative evidence
Certainly.
here. The experts testified that that children who undergo this type of abuse usually suffer certain problems before they recover the memories. The victim here suffered those types of problems, such as alcohol and substance abuse, gambling, difficulty forming trusting relationships. The experts testified that often when memories are recovered, there is a triggering event that causes them to come flooding back. The victim here experienced a classic triggering event in the 2 telephone calls from his girlfriend. The experts here testified that often when victims recover this memory, they are also accompanied by physical and mental manifestations. The victim here suffered serious physical, documented physical manifestations, and mentally and emotionally virtually had a breakdown. The experts here testified that often when memories are recovered of a true event, that the victim's life will experience an abrupt change. The victim had been doing very well in the Air Force. Within a matter of a couple weeks, he ended up hospitalized and was discharged from the Air Force.
That was after the telephone calls, correct?
All of this was, yes, this was after the telephone calls, within a couple weeks after the telephone calls. There also was corroboration.
Yeah, I'm just going to say, we're going to have to cut off your continuing that, but there may be other questions from the bench. Justice Cowan.
I have two questions briefly answered. One is about the statute of limitations, which is not an element. How much evidence do you say the defendant must put forward on that issue before the Commonwealth needs to rebut it? Should it be enough evidence to warrant a finding that he was absent from the state, or what?
Your Honor, I'm going to defer to Ms.
Oh, no,
Stevens
she's not going to have a
on
whole.
that.
She's not going to have a whole argument.
I understand, Your Honor.
You've used up all of your time, so can you answer quickly?
No, I would prefer to put, if
You may
Well,
prefer-
let me just say one other thing to
Yes,
you.
Your
In your
Honor.
brief on page 5, you said that the defense called Dr. James Chu as a witness at the
At the
hearing on the
hearing.
motion to suppress. Is that correct?
He had been retained by the Commonwealth, but the defense did call him at the Lanigan hearing. Yes, Your Honor.
Well, I wonder what that does then to the defendant's claim that there was ineffective assistance because the defense didn't present any testimony at the motion to suppress. I don't understand why the defense called him. Well, you wouldn't know either, but all
Well,
right.
I believe the justification was that at the time there was some question about whether, about the fit of the named victim here and the diagnosis, and that he called him for that purpose. But ultimately, the judge correctly left that issue solely to the jury, and that they evaluated the victim's testimony and evidently believed him. Thank you.
Good morning, Your Honors. We'd split our time for 10 minutes on
No,
the repress.
your time is, all of the time was used up, so you don't have 5 minutes. You can answer Justice Cowan's question briefly.
Whatever the court would prefer.
Yes, my question was, how much evidence does the Commonwealth argue the defendant must put forward on the statute of limitations issue before the Commonwealth needs to rebut it? Should it be enough evidence to warrant a finding that he was absent from the state?
It should be at least some evidence to at least raise the issue so that there's something to be
I
disproved.
know you say in your brief some evidence, but I'm asking you how much, enough to warrant a finding, which is the standard, I think, for to get a self-defense instruction.
It should be enough to find as a matter of law that the statute has run, and then the Commonwealth would have to disprove it. And I would just ask the court that it would be not just the time has run, but time plus residency, so that then we would have something to disprove.
Okay. Thank you.
Thank you. If there are no further questions, thank you. Good morning, Mr. Corber.